Submissions now will be under the heading, and we'll deal with the topic of the non-delegable duty. The first topic is deliberate acts. The respondent says that an intentional tort cannot amount to a breach of a non-delegable duty. And so the question here is whether the assumption of responsibility, which was the cornerstone of the decision in Annie Woodland's case, might include or necessarily excludes an obligation to refrain from the commission of intentional torts. Woodland, as the court will know, was a case where negligence was alleged against a lifeguard and a swimming teacher running a swimming lesson in a local pool, school swimming lesson, and the school in question was under the purview of Essex County Council. But they were independent contractors, the swimming teacher and the lifeguard. And so the claimant could not rely on the doctrine of vicarious liability. The case came before this court, which decided that Essex County Council carried a non-delegable duty that would be broken by negligence on the part of those to whom it had delegated the function of teaching swimming. So the structure is Essex has a duty. Encompassed within that duty are a number of functions, and it delegated the performance of a function to those mentioned, the swimming teacher and the lifeguard. Three important points to be made at this stage. First, and this is the bluntest, but perhaps, I don't know, it's for others to say, the most powerful point. When we are considering the liability of institutions for acts committed by those to whom care functions have been delegated, should we exclude deliberate assaults when the whole foundation of that liability can be seen to be based in an assumption of responsibility to protect the vulnerable from harm? Our argument is that the answer must be that we should not exclude deliberate assaults. The second point is this, and it's an illustration really of where we might end up. In Annie Woodland's case, after the Supreme Court hearing, there was a contested trial on the facts which Annie Woodland won. There was no allegation of assault there because the allegations were that she'd suffered her brain injury as a result of a failure to supervise her properly in the pool. But if this part of the defendant's case is correct, and had the swimming teacher instead assaulted Annie Woodland, Essex would not have been liable. Now that may not be directly of concern to this particular appellant because she has available to her, we would say, the remedy of vicarious liability. But this morning we've heard about how independent businesses may carry out the fostering job, running, to quote the words from Cox, they're entirely their own separate business. And so it has potential ramifications for others, even if you find in favour of this appellant on the topic of vicarious liability. because, as we know, the very reason why non-delegable duties arise is because of the absence of vicarious liability, as Lord Sumption said in Annie Woodland's case. That's the second point. And the third point is this, turning really the other side's argument on its head, because they say, oh, you mustn't dress up an assault as a failure to take care. But the difficulty will be that if you accept that argument, then cases like this, if the non-delegable duty only includes the tort of negligence, then on another occasion, someone will allege against the local authority a failure by a husband to supervise the wife, for example, or vice versa, or a failure properly to nurture a child, when actually So I think we need to, I submit, that we need to grab the nettle, really.
But it depends how you frame the non-delegable duty. If you frame it in terms of negligence, well, then that's going to provide the inevitable answer. But if, by contrast, you frame it on the basis that the non-delegable duty is to hold the child free from harm, then a very different answer is possibly produced.
We agree. And we wouldn't...
I understand that entirely, but how far does it go? Free from all harm?
No, because...
Can it?
No.
Well, as framed by my lord, of course, that would include a strict liability for any harm, however.
Yeah.
Yes, well, obviously it requires qualification. I mean, it's merely a first attempt at trying to frame the context. And obviously,
So,
not suggesting that it necessarily imposes a strict liability, but if it is framed in this way, that you hold the child free from avoidable harm that you can, by your actions or inaction, avoid.
or harm that is in breach of duty, whether that be a duty framed in the law of negligence, or whether it also be framed in terms of a duty not to assault the child.
Is an assault a breach of the duty of care? And if not, why not?
An assault, the authorities say, should be regarded as just that, as an intentional tort.
Well, I understand that, of
Yeah.
course.
Yeah.
But if I'm under a duty to take reasonable care for the safety of somebody, and I assault them, am I in breach of my duty or not? And if not, why not?
Yes, and I don't need to answer the second.
Right.
Why are you? Because by slapping, just take the basic example of slapping a child, for example.
Yes.
There's a duty to take reasonable steps to protect the child from foreseeable harm. And the duty is broken when you slap the child intentionally. But they are, I mean, I know that the Lord has this on board already. They are separate torts.
Oh, yeah.
But there is another way of addressing this, which I hope to sort of elaborate upon. But I think, because I know not all of, I can't remember, but I know that certainly not all of the members of this court were members of the court in Woodland. And so it will help, I think, perhaps at this stage, to deal with Lord Sumption's analysis of the evolution of the non-delegable duty. And the case...
Can I ask you just...
Woodland is at tab 18 of the authorities bundle.
Can I ask Mr. Moulton, just so I understand the structure of this analysis? A point that Lord Justice Burnett emphasised was the existence of a statutory provision imposing on the local authority the same duties as those of a parent. Now, I think it's common ground that the parent wouldn't be under the non-delegable duty that you've described. So I'm wondering, is this, do you see this is your argument that this is a common law duty which exists alongside the statutory duty, or what?
Our argument is that the defendant was under a common law duty running parallel to its statutory duty. Yeah. So the statutory duty, the council has the powers and responsibilities and duties of the parent. Those duties include an obligation to maintain and to accommodate. And what we say is that, I'll come on to it shortly, but the function delegated was the provision of accommodation and maintenance.
Yeah. And so the net result is that the local authority is under a more onerous duty towards the child than a parent would be.
We say so, yes.
Yeah.
And the courts have recognised, Lady Hale mentioned towards the end, I think, of the Woodland judgment, but the courts have been slow to impose duties on parents arising out of the case of Surtees, I think it was. And so for that reason, we say the position of parents is different from that of the local authority. So if we look at Lord Sumption's identification of the issue to begin with, it's at page 1142 of the memory stick. And it is very helpful, I think, that this be read, and I hope it will also be helpful if I read it. So, number 4, the issue on this appeal is, however, nothing to do with vicarious liability, except in the sense that it only arises because there is none. On the footing that the local authority was not vicariously liable for the negligence of the swimming teachers, etc., the question is, what was the scope of the authority's duty to pupils in its care? Was it a duty to take reasonable care in the performance of the functions entrusted to it, so far as it performed those functions itself, through its own employees, and perhaps one might put in only so far as it performed those functions itself through its own employees, or, and this is the extension, or was it a duty to procure that reasonable care was taken in their performance, and I've written in here, in other words, in the performance of those functions, by whomever it might get to perform them? On either view, any liability of the education authority for breach of it is personal, not vicarious. The law of negligence is generally, the next paragraph I think the court can read to itself. It's just adopting the words of Justice Corey, another way of expressing the distinction between the personal duty and the non-delegable duty. Now, the last part of that under letter B, the expression non-delegable duty has become the conventional way of describing those cases in which the ordinary principle is displaced and the duty extends beyond being careful to procuring the careful performance of work delegated to others. But we could substitute, with no disrespect to the principle or the reasoning of Lord Sumption at this stage in the court generally, and the duty extends beyond not assaulting to procuring that no assault is committed by those to whom the work is delegated. And Lord Sumption uses both the word work and function. So this is it's the task or the job that's being delegated. The duty itself, although we talk about non-delegable duty, rests with the impugned party. And then in paragraph 6, what Lord Sumption does is to describe other contexts in which non-delegable duties have been found, or another category, but then 7 is the important one, and I'm going to read it out because it is so important. The second category of non-delegable duty is, however, directly in point to the case of a swimming lesson with a young girl. It comprises cases where the common law imposes a duty on the defendant which has 3 critical characteristics. So we have the 3 critical characteristics here. Shortly we'll see the 5 important factors. But the 3 critical characteristics are, first, it arises not from the negligent, and we might substitute tortious here if we're worried about assault. It arises not from the negligent character of the act itself, but because of an antecedent relationship between the defendant and the claimant. In other words, whereas normally you are only liable in negligence for that which you do, the work that you do, and when you do it carelessly, in these situations that define non-delegable duty, it's the antecedent relationship, and this is a protective relationship, as we'll shortly see, that is the first cornerstone, if you can have more than one cornerstone, first cornerstone of the principle. Second, and I've put in non-delegable, the non-delegable duty is a positive, or another way of expressing it, affirmative duty to protect a particular class of persons against a particular class of risks, and not simply a duty to refrain from acting in a way that foreseeably causes injury. And so, second cornerstone is this affirmative duty to protect. And it would be unfortunate if a doctrine, the basis of which rests in the desire to protect particular classes of persons, they should not be protected from an assault. And then third, the duty, the non-delegable duty, is by virtue of that relationship personal to the defendant. So, in other words, the crucial element here is the relationship between the tortfeasor and the eventual victim, not as in vicarious liability, the relationship between the tortfeasor and the tortfeasor's, for want of a better word, agent, delegate. So this is extremely important, we say.
There obviously is such a category of duties, and I've often wondered about this. Does the third of those propositions actually do more than, as it were, to state the conclusion?
It does no more than state. It does more than state the conclusion, because what it tells you is that it's the relationship, the antecedent relationship, that is responsible for the personal nature of the duty.
Which is the first one, but yes, okay, yeah. They go together,
So,
obviously.
And the relationships, the examples are several now,
Yeah.
but a school has that relationship with a school child. And it's antecedent in the sense that it precedes the event giving rise to the harm. Now, and this is the function or the work or the job, whatever, the work required to perform such a duty may well be delegable, and usually is. The delegation of the work here is looking after the child, maintaining the child, accommodating the child, or in another case, teaching the child swimming. So that's the work done as part of the duty. But the duty itself, and we'll come to its scope in due course, because it's all based on assumption of responsibility, but the duty itself remains the defendant's. Its delegation makes no difference, according to Lord Sumption, to his legal responsibility for the proper performance of a duty which is, in law, his own. So the duty to procure that care be taken is adherent. It sticks with the defendant who owes this duty, regardless of the fact that he may delegate elements of its performance to others. And in these cases, Lord Sumption said, the defendant is assuming a liability analogous to that assumed by a person who contracts to do work carefully. The contracting party will normally be taken to contract that the work will be done carefully by whomever he may get to do it, photo production, Securicorps. The analogy with public services is often close, especially in the domain of hospital treatment in the NHS or over the page, education at a local education authority school, where only the absence of consideration distinguishes them from the private hospital or the fee-paying school performing the same functions under the contract. And then, and this is an important glimpse into the Supreme Court's thinking, because they refer to Lord Denning's reasoning for his decision in Morris, which I openly concede was in the minority. In other words, the other two Lord Justices decided on different grounds. But I'll read it out because it is so important. In the law of tort, the same consequence follows, as in contract, where a statute imposes on the defendant personally a positive duty to perform some function or to carry out some operation, but he performs that duty by entrusting the work to someone else for whose proper performance he is legally responsible. In Morris and Martin, Lord Denning, Master of the Rolls, analysed the liability of a non-contractual bailiff award in similar terms as depending on his duty to procure that proper care was exercised in the custody of the goods bailed. So, now, what we say, and we can come back to Morris and Martin, but only briefly, because I think the point's made, the duty to protect against a particular class of risks should not, in this case, be so narrowly drawn as to exclude intentional torts. Lord Sumption went on to quote Lord Blackburn's words in Hughes and Percival in paragraph 10, facing page, memory stick 1145. And then in paragraph 11, and I'm going to read this out, but what he did in paragraph 11 was to summarise the crucial role played in this doctrine by the concept of assumption of responsibility. Because we say that it's in its foundation, in the concept of assumption of responsibility, that determines the scope of the duty, which is non-delegable. And here we say there is absolutely no good reason whatsoever why this duty, why the scope of this duty, determined that as it must be by assumption of responsibility, should not include that duty to assume. Or are we to say, as here, that the nature of the antecedent relationship between the council and Natasha Arms was such that the affirmative or positive duty to protect her did not extend to protecting her from an assault by the delegate. That's the issue. So what Lord Sumption said was this: the duty to which, paragraph 11, bottom of 1145, the duty to which Lord Blackburn was referring would today be regarded as arising from an assumption of responsibility imputed. So it's an assumption, but in a sense, it's an assumption that's shoved onto the defendant by being imputed. Is imputed to the defendant by virtue of the special character of his relationship with the claimant. The concept of an assumption of responsibility is usually relevant in the law of negligence as a tool for determining whether a duty of care is owed to protect against a purely economic loss. There's no doubt in this case that the Education Authority owed a duty of care to its pupils to protect them from injury. But the concept of assumption of responsibility is relevant to determine its scope. I.e. the scope of the non-delegable duty. And for our purposes, was the non-delegable duty, was its scope limited to cases in negligence, or could it, if we follow this reasoning, properly extend to assaults? The circumstances, second line from the bottom, must be such that the defendant can be taken not just to have assumed a positive duty, but to have assumed responsibility for the exercise of due care, I might say, for the restraining from assaulting, for the restraining of deliberately inflicting harm by anyone to whom he may delegate its performance. That's the performance of the work, not, of course, of the duty. This, he says, obviously, is a markedly more onerous obligation. But what are the circumstances in which a person may be taken to have assumed the responsibility? They've been considered in a number of cases involving injuries sustained by employees, hospital patients, school pupils, and invitees at the hands of various persons working for the defendant, for whom the defendant was not vicariously liable. Paragraph 14 next. I move to the hospital cases because the important cases are directly in point. But the argument, as we will see, and the basis for the judgment in Woodland was really built on the hospital cases from the 40s and 50s and 60s. This was a time of transition when the NHS was in its relatively formative years. And hospital boards were saying, well, we can't be liable for what doctors do wrong because we don't have the skills that they do. Background to these series of cases. And that's the number 14. In Gold v. Essex Council, the hospital was held liable for the negligence of a radiographer. The decision was an orthodox application of the doctrine of vicarious liability. The main issue was whether the authority could be vicariously liable even for employees, where they had to exercise a special skill. Lord Green, Master of the Rolls, however, considered more broadly the basis of the hospital's liability for the negligence of those through whom it discharged its duty of care to patients. And this helps us towards deciding, well, what is the assumption of responsibility, or what is the scope of the duty for which responsibility is assumed. The extent of the obligation which one person assumes towards another is to be inferred from the circumstances of the case. This is true whether the relationship is contractual or non-contractual. In the former case, there is, of course, a remedy in contract, while in the latter, the only remedy is in tort. But in each case, the first task, according to Lord Green, was to discover the extent of the obligation, or to use another word, the scope of the obligation assumed. by the person whom it is sought to make liable. So our first task, it might be said, is to discover the scope of the obligation to Natasha Arms. In other words, was it not to be negligent towards her, or did it include also not assaulting her? Once this is discovered, it follows of necessity that the person accused of a breach of the obligation cannot escape liability because he's employed another person, whether a servant or agent, to discharge it on his behalf. And this is equally true whether or not that obligation involves the use of skill. That's the important part of that extract from Lord Green's judgment. One needs, in other words, to look at all the circumstances to decide what is the scope or extent of the obligation. Now, there's nothing in the quoted extracts from the next cases, Cassidy in the Ministry of Health and Rowe in the Ministry of Health, to justify the exclusion of intentional torts from the non-delegable duty doctrine. And the quoted extracts quoted by Lord Sumption from the Australian cases emphasise the particular responsibility of institutional defendants for the safeguarding of the vulnerable in their care. If, as we say it is, the protection of this vulnerable class is an important, decisive, essential factor, there's no reason why deliberate tort should be excluded. Indeed, it might be said that the opposite is true of a child who is being placed in the private home of a foster carer. Because the class of persons to be protected has to be protected against a particular class of risks. Children in care occupy that class, and the risk of their being abused, it may be said, may be greater if there's the potential for that to be committed behind closed doors and in the custody or charge of people who have the responsibility to discipline that child. So when we look through the papers, you see that numerous people say, and it makes sense, that the council can't be seen to undermine the authority to discipline the parents, because that would be inconsistent with family life. But we know from this case, but also from many, many other cases, that abusers use their position of power and authority to encourage the child to keep silent.
Can I ask this, Mr. Milton? Section 24 of the 1969 Act and, as reenacted, Section 10 of the 1980 Act provide that a local authority shall have the same powers and duties with respect to a person in their care by virtue of a care order as the parent would have apart from the order, and may, without prejudice to the preceding provisions, restrict his liberty to such extent as the authority considers appropriate. So if one asks, what's the source, what is the legal basis of foster parents, for example, saying, go to your room, or no, you can't go out on Friday night with your friends, you must remain at home, say. What legal right do they have to restrict the child's movements, for example? The answer would seem to, subject to any correction you may have, the answer would seem to be the right to do that must be derived from the powers given to the local authority by statute. Am I right about
Yeah,
that?
well, they have no, well, to answer the question in parts, if I may, and the foster parents obviously have no power directly conferred upon them by statute.
No.
The parents do not give them that power, and they would normally have the power. And so the local authority can be the only source for the foster parents of that power.
Because at common law, foster parents don't have such a power, I presume, because they're not in any relationship, they're not in relation of a child's. And statute doesn't give it to them unless it's via the statute, unless it's via the local authority.
I agree.
Well,
If that's right, that might be quite important for the vicarious liability aspect of the case, as well as for the aspect that you're discussing at the moment. And if the source of the parental powers being exercised by foster parents are those conferred on the local authority, I'd have thought that bears on this morning's argument.
In the sense that if one's, well, I suppose the second, third and fourth questions are they acting on behalf of, and it's the integration point, it's those two, isn't it?
Exactly.
And I haven't thought it through, but it seems to me, for the time being, that if the foster parents are in maintaining and bringing up the child, in doing so, if they are acting only as the result of an authority conferred through the council, then that would be an extra matter that could be said to show that they are integrated in the structure.
maybe so,
Yes.
but you will have to reflect on Section 3, subsection 5 of the Children Act 1989, which was probably enacted, although I'd have to check, in the belief that it reflected the common law. And this provides that. I'm not sure that we have it.
Yes, we have behind tab 4.
Oh, that's good.
Section 3, subsection 5.
Yes, a person who A, does not have parental responsibility for a particular child, but B, has care of the child, and that means actual care of the child, may, subject to the provisions of this Act, do what is reasonable in all the circumstances of the case for the purpose of safeguarding or promoting the child's welfare. So if you've actually got hold of the child, you can do what's reasonable in all the circumstances, like stop them running into the road or whatever.
It's arguably a freestanding common law duty if you are acting in loco parentis to promote the welfare of the child. I mean, if you are the person who has the day-to-day control of the child, it seems to me that it must be arguable that you have a common law obligation to take steps to promote the welfare, at least to protect the child from harm.
Well, that's sitting in Section 1 of the Children and Young Persons Act 1933 as well.
Yeah, well, you wouldn't need to have day-to-day care, would you? I mean, if you take your friend or next door neighbour's child with yours on holiday or to school or whatever for the time being, you clearly have some common law powers, of which this is declaratory. But well, let's come on.
Yeah.
The problem is,
I mean,
they're the powers of the parent, aren't they? The powers that the local authority is given under the Act are the powers of the parent. And I don't know whether you agree or not, but does it follow that the foster parent's powers and duties are also those of the parent?
Save and insofar as the local authority says, no, you can't do that.
Unless curtailed,
Which
yes.
they often do.
David and Les Curta, yes, indeed.
Yeah. Now, the parent, does the parent owe a non-delegable duty to his child?
parent does... The parent does not owe a non-delegable... Well, let me put it this way. If one looks at Lord Assumption's criteria and will examine them, the answer would be no. But also, we will say that one should not be timid about making a local authority responsible just because they have parental responsibility, if our fear is that we might be making parents responsible. And there are safeguards that we can build in. But this is all about context, and if the source of this obligation is an assumption of responsibility, which we say it is, and an assumption of responsibility in context, then what we say is that the council, to use the assumes this in all the circumstances of this case, assumes the responsibility
Of the parent?
No,
Now you're back to square one.
No. Well,
It assumes a duty to the child, whereas arguably, I don't know what the answer to this is, but arguably the obligation devolves on the parent not by a proactive assumption of responsibility, but by dint of being the parent of the child.
But, well...
It might be a slightly artificial distinction,
but
I mean, the assumption of responsibility, I know it's called an assumption of responsibility, but as I think you pointed out, it isn't really an assumption. It's an imposition for good reason by the law. It is actually, I think, probably possible to think of a local authority assuming responsibility because it takes a positive, proactive decision to seek an order for care or whatever, or at least it may do. It's not the only situation, but it might do. But whether schools who may or may not have much control over who comes to them can really be described as assuming responsibility for their children, it's perhaps less clear. And it's quite clear that the non-delegable duty applies in other cases where it isn't really a question of assumption at all. It's a question of imposition for good reason.
well, I'm in the position where that I may like to agree, but since Lord Sumption based the decision on assumption of responsibility, what I've taken it as being is a use of language, legal language, that doesn't mean voluntary assumption in the way that we might use it.
Well, by admitting a patient to your hospital or a child to your school, and these are principally decisions of the hospital and school, although in the school case they're subject to appeal, hospital case not, but by admitting the patient or the pupil, that is an assumption of a relationship with the child, the patient or the pupil, which imposes upon you certain responsibilities.
And so the
That's a way
abbreviated way of putting it is to say that that's an assumption of responsibility.
Okay.
And so what I was saying, I was just dealing with the special class points, just to go back to where I was up to. And what I had just said was that children in care occupying the class and the risk of them being abused behind closed doors, etc. And one can look briefly at, on the next page, which I think is 1150, when the assumption trawled through the Australian authorities. Paragraph 30 within Intravene, which was the swirling around the Maple case. Paragraph 30, there are strong reasons, it was said in Intravene, for saying it is appropriate, etc., etc. The immaturity and inexperience of the pupils and their propensity for mischief suggests there should be a special responsibility on a school authority to care for their safety, one that goes beyond a mere vicarious liability for the acts and omissions of its servants. And that was cited by Lord Sumption as just part of the build-up to and part of the workup, that this is to do with vulnerable people, whether because of mischief or whether because of immaturity. And the same goes for the facing page, 1151, the citation from the Australian case of Condis, paragraph 33, just the last 6 or 7 lines or so. This was a case about contiguous buildings. No, this was the employer case, I'm sorry. Anyway, it doesn't matter. E. In these situations, the special duty arises because the person on whom it is imposed has undertaken, and we can almost assume there, undertaken the care, supervision or control of the person or property of another, or, so that's the undertaking, so that's the voluntary undertaking part, so that's partly with what Lord Hughes is saying, or is so placed in relation to that person or his property as to assume a particular responsibility for his or its safety in circumstances where the person affected might reasonably expect that due care will be exercised. So that's the sort of interplay between the words of undertaking care and assuming responsibility. But what we say that you need to do is look at all the circumstances, look at the context, and decide what assumption of responsibility should be imputed. Now, Lord Sumption then distilled from the authorities a number of, I think 5 again, defining features and listed them at paragraph 23. And before reading out the paragraph, which I need to do, we make the point that none of these would naturally, whether in the words used, and we don't need to interpret them as a statute, or in their sense, exclude the deliberate tort. And we would secondly say, before reading the paragraph, that the duty assumed is a positive duty to protect from harm. So, in the first 6 lines or so of paragraph 23 at page 1153, Lord Sumption said, "In my view, the time's come to recognise that Lord Green and Lord Denning were right in those cases in identifying the underlying principle. And whilst he says, I would not necessarily subscribe to every dictum in the Australian cases, in my opinion, they're broadly correct in their analysis of the factors that have given rise. And if the highway and hazard cases are put to one side, the remaining cases are characterised by the following defining features. 1, the claimant is a patient or a child, or for some other reason is especially vulnerable or dependent on the protection of the defendant against the risk of injury. Other examples would be prisoners and residents in care homes, and I might say residential homes for children. 2, there is an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission itself, which does 2 things. 1, which places the claimant in the actual custody, charge or care of the defendant. And 2, and this is the more controversial bit, from which it is possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm. And not just a duty to refrain from conduct which will foreseeably damage the claimant. It's characteristic of these relationships that they involve an element of control over the claimant, which varies in intensity from one situation to another, but is clearly very substantial in the case of school children. The third defining feature, the claimant, that's the child in this case, Natasha in this case, has no control over how the defendant chooses to perform those obligations, i.e. whether personally or through employees or through third parties, which is obviously present here. 4, this is important because the defendants say this doesn't exist here. The defendant has delegated to a third party some function, maintenance accommodation, bringing up, which is an integral part, and so this is familiar to us from the vicarious liability doctrine, which is an integral part of the positive duty which he has assumed towards the claimant. So the positive duty, we can see from 7 or 8 lines up, is to protect the claimant from harm. That's the imputed or the assumed duty, responsibility. By virtue of my position and by virtue of all the circumstances in this case, I assume a positive duty to protect the claimant from harm, is how we put it. So the defendant has delegated to a third party some function which is an integral part of the positive duty which he has assumed towards the claimant. And the third party, the foster parent, is exercising for the purpose of the function delegated to him, maintenance of the child, the defendant's custody or care of the claimant, and the element of control that goes with it. And 5, the third party has been negligent, not in some collateral respect, but in the performance of the very function assumed by the defendant and delegated by the defendant to him. So that's those are the 5 characteristic features. And
they might exist, might they, where the defendant, if you like, in this case, was the parent who had sent the children to stay with the aunt, knowing perhaps that the aunt will then allow her children to look after the children. Those facts or something similar to them would be sufficient to amount to liability on the part of the parents. And it would be quite easy at any rate, not that I've actually done it, but it would be quite easy at any rate to generate something along those lines based upon this analysis. I'm not saying that's wrong, but I mean, no. the principal basis on which you've lost so far has been compare the parents. Foster parents are really the sort of parent, and if there aren't going to be these liabilities in the case of a parent, then how can it be in the case of
well, in the case of a parent, of course,
of an employer? I mean, I can see you've got the point about all the points you've been discussing this morning.
But there is another point that is the domestic examples. It's the case of Surtees. So the courts have been very slow.
Right.
Curtis was a scalding case against foster parents. Surprisingly, the judge at first instance found that there had been no breach of a duty to protect from harm. And but what Lady Hale said at the end of Woodland was the courts are slow to impose duties on parents in the familial setting. And that's regulated.
This is the poor old parent point, right?
This is the poor old parent. Or, you leave the Hoover at the top of the stairs intending to remove it, and then your wife or husband trips over it. Well, would a reasonable husband do that?
It's all in the interest of domestic harmony.
Indeed.
And good relationships, isn't
or
it?
Or Dyson, indeed. So, notably also paragraph 24, and I'll come to that in a second, the function, I've made this point already, that we say delegated is to accommodate and maintain Natasha. There may not, for these purposes, even be vestigial control, that word again, over the environment. The relevant control here is over the injured person, and that's a distinction. So,
yes, I mean, once you get to from your point of view, the beauty of the non-delegable duty is you're not interested in control, are you?
Control, absolutely. The duty is to refrain from harming the child, to protect the child from harm. Or to procure that those doing the work of accommodating and maintaining the child refrain from harming her. So, yes, so in paragraph 24, Lord Sumption dealt with A and the Ministry of Defence. This is where the service person's wife was dealt with in Germany, and the claimant tried to say there was a non-delegable duty, but the court said not. And what Lord Sumption said is, last 3.5 lines, where a non-delegable duty arises, the defendant is liable, not because he has control, but in spite of the fact that he may have none. The essential element, in my view, is not control of the environment in which the claimant is injured, but control of the claimant for the purpose of performing a function for which a defendant has assumed responsibility. Now, I'll mention, but we don't need to go to it, Mr. Justice Mayles dealt with this in paragraphs 197 to 211 of his judgment. That's page 15, CB/7151. And His Honour Judge Godsmark Queen's Counsel in JB and BB, I'm not going to take you to this, at paragraph 101, dealt with it, AB, Authorities Bundle /7/226. I'll just say his words. The duty to take reasonable care for the safety of a child is the same as the duty to take reasonable steps to protect a child from harm, which would be broken by assaulting the child. What happened in the Court of Appeal, as the court knows, is Lady Justice Black limited her discussion of the topic and preferred that it be absorbed into her consideration of whether it was fair, just and reasonable to impute the assumption of responsibility. That's 57 to 60 of the court held decision. She did, however, state that she thought that a non-delegable duty could extend in appropriate circumstances to a duty not to assault the child. Lord Justice Tomlinson said that the issue, he addressed it, but said it didn't arise on his analysis. And as Lord Reid has said already, Lord Justice Burnett approached the case on this. He decided that the commission of an intentional tort couldn't amount to a breach of such a duty. Now, his preferred formulation was the duty, so far as reasonably practicable, to care for the child, to promote her welfare and to protect her from harm. But whether you write the duty in that way, and we would rather not, we say that that can include and should include a duty to refrain from injuring her, for example, by assaulting her. But what Lord Justice Burnett also did was to say, and this is what is echoed over to the other, on the other side of the room, they say, well, we should not ignore the carefully calibrated controls derived from the doctrine of vicarious liability. And so that was one of the reasons why he, and actually also some of the judges in the High Court in Australia in Lepore said either, well, we don't need to go this far because vicarious liability will do. But for the reasons I've hinted at already, it may not matter enormously to Natasha Arms, we'll only learn in due course, but it is something that needs to be understood.
Well, all of the judges except one in Lepore positively decided, didn't they, on the deliberate act point.
They did.
In a sense, contrary to what you're now urging on us.
They did.
And as far as I can see, what they said was that the reason why you shouldn't extend the concept of the non-delegable duty to liability for the deliberate act was that was in some way severing the non-delegable duty from the negligence which was its foundation, from the law of negligence which was its foundation. Have I got that right?
Yes, that's one of three. I think there are three reasons that are given. One is, well, it started off in negligence, and so we really don't want to divorce it from that. But when we see, I would say this, wouldn't I, the very carefully constructed analysis by Lord Sumption in Woodland. It may be that historically we've dealt with this in cases involving a breach of the common duty of care, but there's nothing in its genesis or in its reasoning that means that it should not apply to cases of intentional torts. So, yes, historically it is true there has been that association, but that association is one, and this happens in the law, doesn't it, that happens, as it were, by accident and by serendipity. And we have so far chosen, in these cases, to go down the vicarious liability route. But all we need is for a boy or a girl to be assaulted, to be abused by someone who is very much running their own business, for them arguably not to be able to avail themselves of the vicarious liability route. And so, with them in mind, we need to be careful not to say, not to shove it all over to vicarious liability. So that was one of the reasons. Another reason was, well, and I might need to develop this a bit more tomorrow because I'm going to finish before 3:30, or I want to finish before 3:30. I will finish before 3:30. Sorry. Whatever happens.
Come what may.
Yeah, I may finish sooner. But sorry, I put myself off. The second point is, yes, well, if you extend vicarious liability to if you extend the application of the non-delegable duty to intentional torts, then you'll have this, you'll have two men fighting at work, and because the employer owes the victim a non-delegable duty, then when they punch each other at work, then there'll be liability, and that shouldn't be covered. Well, we say two things about that. One is, well, actually, in the appropriate circumstances, it might not be inappropriate to have it anyway. But more importantly, there are separate strands of non-delegable duties, and this is the protective vulnerable person strand. You can't shoehorn an employee into this line of authorities described and summarised by Lord Sumption. But of course they didn't know that in Australia in 2000 and whenever it was, because they hadn't worked it out in the way that we since have. It was as if they were saying, right, well, non-delegable duty is non-delegable duty, and let's see how, with no disrespect, of course, let's come up with some examples which demonstrate the fallacy of the application, whereas actually we can control this mechanism by focusing on what is the assumption of responsibility and what are the circumstances, and of course ultimately by the catch-all, if you want to use it, of well, it's not fair and just and reasonable, A, to make for example, to make the local authority liable for what the parents do, or B, to make an employer liable for what for the punch-up at work. So those are two of the elements of the reasoning in Lepore. And the third was it was quite hard to, I didn't understand fully the reasoning of Justice Gaudron. But there was a concern also that it would impose strict liability. That was the third point. But it needn't, except in appropriate circumstances. All of this can be, to use the word, calibrated or controlled by the device given to us in Woodland by the Supreme Court. Now, Morris and Martin is authority, we say, for the contrary conclusion. The other side say, well, it was only in the minority. What we say is, well, Lord Sumption relied on it, and the Supreme Court relied on it as part of the thinking in Woodland, and as it were, that's good enough for us. Can I then come on to the next topic within vicarious liability, is the fourth defining feature. As we've just seen, the fourth defining feature from Woodland is that the defendant has delegated...
This is not vicarious liability we're on now, is it?
No, we're still on, we're staying...
Sorry, I think you just said a member's guilt.
Yep. Yeah. It is confusing, I must say, because we have 5 factors or defining features. Potentially confusing. Number 4 on 1153, the defendant has delegated to a third party some function which is an integral part of the positive duty which he has assumed towards the claimant, and the third party is exercising for the purpose of the function thus delegated to him, the defendant's custody or care of the claimant, and the element of control that goes with it. Well, what we say quite simply is this, that the duty, the positive duty assumed towards the claimant was to protect her from harm, and the function, it was the function that was delegated, not the duty, not least because you can't delegate it, and that was to accommodate and maintain Natasha. It was to look after her on a day-to-day basis, which is part and parcel of the parental responsibilities that the local authority assumed. Mr. Justice Mayles dealt with this at paragraph 195, and I'll read out his words without taking you to them. The positive duty which the local authority assumes is to care for the child. We might say to protect the child from harm. But care and protection of the child from harm, he says, which is an integral part of the overall duty, is delegated to the foster parent or other person with whom the child is placed. The child is placed in the foster parent's care for that purpose, and it's the foster parent who exercises the day-to-day care of the child that goes with such care. And His Honour Judge Godsmark, Queen's Counsel, dealt with the argument in the same way at Authorities Bundle stroke 7 stroke 816. So we say number 4 is present. And now I move on for the last 15 minutes or so to the third headline, which is what is fair, just and reasonable. So, because the criteria identified by Lord, I should say that most of these points are covered in our case, and so if there's something that's significantly different, I'll draw it to your attention. But
is the test the same in the two classes of case or different? I mean, the vicarious liability class of case and the non-delegable duty class of case.
Well, the question is
the same. Are the considerations the same?
They can't be identical because one is dealing with different reasons for imposition of the duty. And it may be that someone will think of an example that would be abhorrent to us all. And so we might always benefit from some safeguard, such as fair, just and reasonable, or, as was said in Cox, looking at authorities in borderline or difficult cases. But so dealing with the question, dealing with vicarious liability, fair, just and reasonable, what was said in Cox, as we read it, was that because the criteria identified by Lord Phillips embody the underlying policy justifying the existence of vicarious liability, it should not be necessary to reassess whether the imposition of liability is just, fair and reasonable, because that reassessment always tends to lead to uncertainty and inconsistency.
I don't have it in front of me, but weren't we responding to an argument that it was necessary to do that in every case?
Yes, well, certainly the response was, you don't need to do it in every case. Well, perhaps I can remind myself of exactly what you said, my lord.
Yes, in paragraph 40, it was argued that it was always necessary to ask the question about fair, just and reasonable. 41, don't consider that it's always necessary, but 42 acknowledged that this was a case where the circumstances hadn't previously been the subject of an authoritative decision, and therefore it was valuable to stand back and consider this question.
That suggests that the reason why it's not necessary to consider it is because it's already been considered in this context before.
Yes.
And obviously you can't keep on revisiting the very same question of fair, just and reasonable in almost identical cases.
Yeah.
Yes, I mean, it's a matter of nuance, I think, but the second part of paragraph 41 does say that was the whole point of seeking to align the criteria with the various policy justifications for its imposition. As I've explained, the criteria may be capable of refinement in particular contexts, but in cases where the criteria are satisfied, it should not generally be necessary to reassess the fairness, justice and reasonableness of the result in the particular case. Such an exercise, if carried out routinely, would be liable to lead to uncertainty and consistency. And so there's many ways of putting it, but I suppose the starting point is stick with the principles unless what you're doing is extending the application of the principle to unusual facts, as novel cases, or as a break on the unintended consequences.
What struck us in that case, in the second half of paragraph 42, was the fact that you had a prison catering team, some of whose members were civilians and others of whom were prisoners. And if somebody working in the kitchen got injured as a result of the negligence of one of these people, it didn't seem fair or just or reasonable that the recovery of damages depended on which particular category the person who dropped the sack of rice in that case belonged to. Now, in our case, I would have thought you might be arguing that if Mr. Bumble and if Mr. and Mrs. Bumble have the Artful Dodger in the workhouse, but they also are fostering Oliver Twist, and Mr. Bumble sexually abuses both boys, it might be thought to be not fair, just, and reasonable that the Artful Dodger has a remedy, but Oliver doesn't, because one of them's in foster care while the other one's
and this
in the
is
workhouse.
the argument. We absolutely make this argument.
But that's exactly the point that I was making in my additional judgment in Woodland.
Yes.
Yes, it is.
And it's what, I mean, I think when we addressed you at the beginning...
Of course, if one of the children was adopted and the other was fostered, there would be a difference.
But it's not an unimportant difference, though.
No, I understand that.
They may both be in the same house, but in different
Capacities.
Well, in Woodland, we had this situation about the private school, and we had that discussion, etc. So I think what I'm really doing, and maybe I'm not doing a very good job of it, is saying that because we say that those principles in Cox apply absolutely fairly and squarely to our case, and because the principles in Woodland also apply to our case, the court should be loath to say, I know this court wouldn't say that, well, we don't like the look of it and so it's not fair, just and reasonable. What it should be is a break against the cases that seem to be taking the principle further than it should be taken. And I'll now I'll piggyback onto the point made by Lord Reid, or just reinforce it. Yes, it is, and it's part of our case, of course, that why, when Natasha Arms had no say as to her destination, whether it was the foster home or the residential home, why should she have had a cast iron case in one and no case in the other?
Yeah. We may be coming to it, Mr. Belton, if you are, please do it in your own time. I'm sorry to sound like a worn record, but at some stage are you going to deal with the correct analysis of the non-delegable duty where the placement under the care order is with family, friends, or indeed the parent?
I'll deal with it now, but I need to refine it tomorrow, but so the learned friends can anticipate what we may be saying. Our position is this, that the placement can take place in many different ways, and in situations where there is a care order and in situations where there is not a care order.
Yes, concentrate for the moment on the one where there's a care order.
If there's a care order, then our submission is that if the local authority places the child with an aunt or uncle, then there should be vicarious liability.
Vicarious or non-delegable?
Well, vicarious liability, yes, and also there should be a non-delegable duty.
Right.
Subject to...
And if they place with the,
parent.
by definition, risky parent, because I mean there won't be a care order unless the parent's some kind of a risk, if they place with the parent, which of course does happen quite a lot in an effort to manage the risk and keep the family going, what then? Then
if the child is still subject to a care order, then the principles enunciated in Cox would lead one to say that there is liability.
The placing
That's for vicarious liability.
Vicarious liability?
That's for vicarious liability, absolutely, yes, because if one applies the 5 criteria in Cox, then well, perhaps it's helpful just to go back to them.
No,
I'll do it in reply if I may.
Yeah.
Because I don't want to run out.
Just as long as we know what you're saying. You're saying if placed with the parent in the kind of situation that I've tried to imagine, that would give rise to vicarious liability of the local authority if the parent then harmed the child. Subject
to the argument that it may, in those situations, not be regarded as being fair, just and reasonable.
Well, that's quite a big if.
But I mean, I suppose it is a fairly big. Would it be fair, just and reasonable?
All depends on the circumstances.
Well, yeah, I mean,
But as a matter of first principle, there should not be any distinction between the parent and the foster parent if the placement is a consequence of the action of the local authority. And if, as you have said, the essential underpinning for the non-delegable duty are the twin factors of the vulnerability of the individual and the antecedent relationship between the individual and the local authority, then those are features which are present in whichever scenario you are addressing.
Indeed.
And it would apply equally, therefore, not simply to an abusing parent, but that may easily happen to a negligent parent. Same point.
It is the same point.
Yeah. Okay.
So imagine I were to appear in front of a first instance judge, and the foster has tripped over the hoover at the top of the stairs. That child would not recover, and so we don't need to fear that we've gone too far, because we have the high threshold, the high standard of care of the certes.
Well, that's a different question, isn't it?
It is a different question.
That's whether negligence has been established. But once it has been established, and it may, after all, one's often talking about extremely risky families. Anyway, there we are.
Yeah,
That's
yeah,
your
yeah.
answer.
Yeah, that's the point.
Okay, thank you. And non-delegable duty?
Yes, for the same reasons, that it's caught by the same principle.
What if there were no care order?
What if there were?
If there were no care order in the parent case? That would radically alter the situation.
If there's no care order, so it's a voluntary placement. I don't know, but I know enough. I think I know enough about this case to be able to answer the question in this case. But
so your answer to this is don't know, is it? Right. Could I ask you?
Well,
I
don't know at the moment. I can try and give you an answer tomorrow.
Well, if the child is still looked after, as I was saying earlier, the local authority continues to owe statutory duties in relation to the looking after of the child. And the local authority would, I would guess, draw quite a distinction between a case in which the child was still looked after, albeit placed at home, and a case where the child was no longer looked after and placed at home. I would have thought, of course.
Yeah, bound to.
Could I ask you one other question? Do we have a copy of certes in the bundle?
No, but I'll get one.
Thank you. Because Lord Sumption has a bit to say on this sort of topic on page 1155, subparagraph 6.
In deciding whether it's just.
I'm not asking you to revisit.
No, not at all. I won't. But actually, it is.
With certes, it was a pretty remarkable fact.
I'd like to read it.
No. Lord Clark mentions it. I was going to come to it, but I'm not going to get time to do so. It is worth reading, particularly the first two paragraphs of Lord Sumption's analysis of what is just, fair and reasonable, because he talks about changing times, and in particular how a child who once might have had a remedy, because all swimming teachers were employed by their local authority in the olden days, and then they're not.
Yeah.
And so, apart from those who worked in private schools. And so it's just those first two paragraphs when my Lord looks at it. I may have time to revisit it tomorrow. So we say that the imposition of vicarious liability is fair, just and reasonable. One, policies described in various claimants. Two, audible voice, meaningful remedy for an innocent victim. Three, difficulties as manifest here in proving professional negligence. Four, the simple fact that it was the council and not the child, not Natasha Arms, who chose the foster parents. Five, possibly a slightly more subtle point, the social utility of fostering cannot be expected to come free from risk. If there are, and as we've seen from the documents there are, fiscal or financial benefits to the local authority in its enterprise, and those benefits can include the upside of being involved in a family, then there is no unfairness if there's a downside. This is a point alluded to in the article cited in Cox by the professor. And
if you choose a much cheaper form of looking after the children for whom you're responsible, that is an upside, but it comes with the downside that you ought to be at least equally responsible for the harm may come
indeed
as a result, as you are when you choose the more expensive form of care.
but if one takes it out of the business context and the cost context, what the article says, I've forgotten is it Professor Bell?
Yes.
Yes, thank you. What Professor Bell says is that the benefits and the burdens need not only be financial, and if part of the objective of this enterprise is to enhance the child's experience. And if in 90 places out of 100 it enhances the child's experience, then you gain that benefit, society gains that benefit in all kinds of intangible ways. But if the downside is that 10 children are abused, then you should be prepared to meet the consequences of that downside. So in other words, if the financial costs were the same, if everything was the same in every other respect, if one reads the article, and I may not be doing the point justice, but if the object is to promote the welfare of children in your authority, and if by going into foster homes 95 out of 100 do well and flourish, then the 5 who don't should not be left without a remedy. Next point. The replication of family life point, we say, is a bad one. The child's perception is that, and everyone's perception, we would say, should be that this is a looked after child. And there is far more to equate its position, that child's position, with the position of the child in a residential home than a child in his or her home. Next, deterrence. This is dealt with in our skeleton. It's never been central in just, fair and reasonable. But one thing that will deter people from having bad systems is knowing that they will be directly liable. Blunt instrument. The learned judge said that an award of damages is a blunt instrument. Well, it happens to be the best we've got, and for every injured person, it is all we can do. We can't turn the clock back. But actually, unless there is a meaningful remedy, then people such as Natasha Arms won't go to court to have their side of the story heard. So it's not a blunt instrument. Burden and defensive practice. This is covered by Jane Austen in her statement. Firstly, when we look at what she says, she seems to think that if liability is found here, there will be liability for any kind of accident, however caused. But what she, I think, intends to say, and what the other side say, is that if we're going to be sued for abuse in the home, then we are really going to have to be far more rigorous and circumspect in our placements, and that is going to come at a cost to society overall. It will deprive the local authority of funds. But this is, we say, illogical. It suggests that social workers will decide not to place children in foster care because of the risk of being sued, rather than because of the risk of relevant abuse being committed. Or, if they really do think that way, then they shouldn't be thinking that way, and it's not something that this course should endorse. It's 3:30. Unless there's anything else, my lady.
Are you sure you've finished, Mr.
I'm sure I've finished.
Because by my clock, you've got another couple of minutes. Would
I won't
you wish
use
to
them.
use them? No. Thank you very much indeed. Thank you. Mr. Davey?
My lady, I don't follow at this stage, thank you.
Yes, Mr. Ford.
My lady, as we've identified in our case, and it seems to be the agreed position, the appeal gives rise to 4 separate issues. The first is whether the relationship in question gives rise to vicarious liability at all. And the other 3 concern the non-delegable duty issues. Firstly, whether the 4th of the defining features is met. Secondly, whether the principle can apply to a deliberate rather than a careless act. And thirdly, whether it's fair, just and reasonable to impose the duty. And I set those out now to make the point that Mr. Weitzman and I have divided our labours in this way. I'm going to deal with the first 2, vicarious liability, and the 4th, woodland criteria. And my other friend's going to deal with the deliberate injury point and the question of whether it's fair, just and reasonable to impose the duty. Lady, the short submission that we make in relation to vicarious liability is this, that the relationship between a local authority and a foster carer is not a relationship of employment, that much is not an issue. It's not a relationship akin to employment. If it needs a label, it is in our submission a relationship akin to that between an employer and his independent contractor. Not, of course, an independent contract in all material respects, not least the absence of a contract. But that is by far, in our submission, the closest analogy and a much closer analogy than that of the relationship of employment.
Do we say there's no contract? What if the local authority didn't pay?
Well, the
Would
payment...
there be a contractual right to the payment as laid down, or only a quasi-contractual claim to a merit?
The payment is in the nature of expenses, and so is always going to...
Read your own council's document.
Well, my lady, no, I'm sorry. It certainly changed later on. The document that appears attached to the statement of Miss Austin is a much later document than the position on the ground in the mid-80s. In fact, there's hardly any evidence in the papers about what the position was about payment in relation to these particular families of foster care. Perhaps fair, in having said that I take the court to what there is. We certainly don't dispute that an allowance was made, but as I read it, all that we have on it is...
Yes, but that would be a contractual entitlement to the allowance.
It may be so, and if it is...
Yeah, an entitlement to the allowance, whether it's contractual or quasi-contractual, may be open to debate. But I was only challenging your statement that there was no contract. It seemed to me to be an astonishing statement.
No contract in the sense that one ordinarily thinks of a contract.
No contract of employment.
Well, certainly no contract of employment, but not the sort of contract where one would expect to see between the employer of an independent contractor and his contractor in most usual circumstances. The situation one is dealing with in this case is, in our submission, unique for reasons that we'll go on to develop. Shall I give the reference to what I think is the only reference to the payment received by the foster carers? In this case, it's page 535, which deals with there being an increase in the boarding out allowance to the tune of 55%.
Yes, that was a deliberate act in relation to the small group home, basically.
Yes.
To up the normal fostering allowance, to recognise the greater difficulties of running such a placement.
When it was
it not?
Designated, there was, yes, when it was designated a family group home according to the document you were taking to earlier, yes.
That's only one of these two sets of foster parents.
It is. It's the first set. Yes,
Definitely,
that's right.
it's promising them more
Yes.
as a result of the particular difficulties
Yes.
of their setup.
Yes.
Either way, they're promising them something.
Oh, yes, I accept that. And if there is a contract in a formal way, then it's not a reason why the relationship is less like an independent contract than I was at first suggesting. But our point remains that the analogy here is not with employment, but with an independent contract.
There's a reference on page 535 to a quotes your memorandum of the 18th of August 1978. Do we have that? I don't have it. I don't take that time now.
I don't think we have, my lord, no. As I'm sure is obvious, this is not anything like the entirety of the documentation that arose in the relevant period. They've been selected, I think, by the appellants to demonstrate various points, but they're certainly not complete. Indeed, one notices, if I may just make the point at 537, this question of the family group foster home, which was designated in 1979, one notices that the second paragraph talks about there being a more formal relationship with the foster carers, which might have been something of significance. But one also sees that there was said to be an accompanying document which would set out all the particulars of that, which hasn't found its way into this bundle, and having checked insofar as I was able to, was not in the original document.
This is page 539.
I'm sorry.
unless it's page 539.
Well, that
At any rate,
doesn't seem to go very much further than the letter.
Were there national regulations in the 80s laying down standard or minimum allowances that were to be paid to foster parents?
I'm not aware of any. None were before the judge, my lady.
But that would be a matter of law. It wouldn't have to be a matter of evidence.
Yes, nobody has adduced those in any of the stages of this hearing. It's certainly never been in dispute that fostering allowances were paid, and as I've indicated, there are snippets of it within the documentation, but...
Well, my recollection is that there were national minimums,
Yes,
which would make sense.
yes. My lady, may I start in dealing with the question of vicarious liability with the statutes? Now, I recognise that you have been taken to those which are the most pertinent, and I'm not going to take you to anything you have been taken to before, but I would like to begin a little earlier and end a little later. There was some discussion about the position now, because inevitably the conclusion of this case is going to have a bearing on the position now, and I'll address that briefly, and we will seek to make sure that the entirety of the relevant material is before the court tomorrow, because at the moment it isn't. But as I say, I'd also like to start a little earlier, just to refer the court to two provisions of the 1948 Children Act, which is a precursor to the 1969 and 1980 Acts, which are directly relevant here. Perhaps, if I may, just to whistle-stop tour through the earlier sections in order to put into context the two sections that I wanted to refer to. Section 1 is the duty to receive the child into care if the parents are or guardian is incapable of providing proper accommodation, maintenance and upbringing.
Well, that's what used to be called voluntary care.
Exactly.
So not what's an issue in this case.
Indeed. Sections 1, 2 and 1, 3 deal with the 1, 3 deals with the power of the parent or guardian to have the child returned, hence obviously, my lady, the voluntary nature of the arrangement. And over the page at section 2, a provision which appears slightly amended in the 1980 Act is the parental rights resolution provision, where the authority can resolve to take over the care of the child in certain circumstances if the parent or guardian is unfit. Section 3, again, we've looked at the later sections that echo, but that deals with the powers of the local authority whilst the parental rights resolution is in force. And section 3.3 is the first of the two sections I wanted to refer the court to. A resolution under section 2 of this act shall not prevent the local authority from allowing, either for a fixed period or until the local authority otherwise determine, the care of the child to be taken over by and the child to be under the control of.
How is that relevant? There was no voluntary care in this case, and there was no section 2 resolution. Section 2, as it was under this.
There wasn't.
There was no resolution. So how is that relevant? There was a care order, which is under the Children and Young Persons Act.
What I'm seeking to...
separate legislation.
I can jump straight to the point. Two points. The first one is that the statutory power to replace the child back with the parents, whether the care is voluntary or whether it is not, has existed since the 1948 Act. That's point one. And so that's one of the sections that goes to demonstrate that point. The other section that demonstrates that point is section 12, which will be 12 and 13, which will be familiar as the precursors to the sections we've looked at in the 1980 Act. And 13.1 is the provision that is the equivalent of the later section, is it 21 in the 1980 Act, which provides for the boarding out of the child, but says this at B, and this is a provision that doesn't appear in later legislation, where it's not practicable or desirable for the time being to make arrangements for boarding out by maintaining the child in a home. So that is to say a home provided by the local authority or a voluntary organisation. So there is, at least in 1948, a statutory preference, as it were, for the use of boarding out, and that is consistent with the prevailing thinking at the time arising out of the Curtis report that children were better placed in a family home than in a care home. Taking matters chronologically, the next piece of legislation, regulations, are the 1955 regulations. Now, you've been taken to some of these before, and I'm not going to read them out, but I wonder if I might simply identify, by way of submission, that these regulations impose obligations on both the authority and on the foster carer, and do so certainly in terms of the local authority, obligations of three types. And might I just identify what in our submission those types of obligation are, and identify those regulations which fall within that category. So firstly, there are obligations which relate to the placement and removal of the child, and those are Regulation 17, which concerns the duty to ascertain the suitability of the placement, Regulation 19, the duty to take into account the child's religious persuasion, Regulation 6, medical examination prior to placement, Regulations 4 and 5, you've been taken to, termination if not in the child's best interests, and power to remove if the conditions are endangering the child's safety or morals. So those are the regulations as we read it, which are in the category of placement and removal. The next category is what we're calling administrative responsibilities, and there are three of these. Regulation 21 is the duty to visit. Regulations 9, duty to report, and 22, duty to review. And regulations 10 and 11, duties to keep records in relation to the child.
Are any of these duties placed on the foster parents?
The only duty placed on the foster parents is under Regulation 20 as we read it.
What page is that?
That's page 1647.
Well, you were telling us about three types of duties on local authorities,
Yes.
and then you were going to say something about what?
I was.
Yes.
I was.
Possibly we better conclude the
I'll do
local
that.
authority duties, just so that I can make a nice...
Certainly, yes. The third category
However,
is...
before doing so, could I not comment that describing the duty to visit and report on, i.e. to inspect and
Yes.
supervise, as an administrative responsibility, is perhaps putting it a little bit low.
Well, I don't in any way mean to suggest that that's not a
It's a safeguarding,
crucial part
it's a
of the
safeguarding
safeguarding.
responsibility.
Absolutely, and it's the earliest manifestation. Well, as far as I know, these are the earliest regulations that deal with boarding out at all. But certainly, in the very first version of the relevant regulations, that duty is there, and it's absolutely crucial and vital. And I don't mean to downplay its significance, but we do. The reason I describe it in that way may perhaps become clear when I make our submission on the third category. The third category is what we are describing as parenting type of obligations. And those are only Regulation 7, which concerns the duty to ensure medical examination during the placement. I think, again, you were taken to that. And Regulation 8, the duty to make arrangements for medical and dental treatment. Please. My learned friend helpfully refers me to Regulation 35. Yes, Regulation 33, I was wrong. There was something called the Children and Young Persons Boarding Out Rules 1946. We may try and dig those out overnight
Yes,
to
it
see.
will probably before that as well.
Yes, maybe. Well, we'll certainly check to see whether they include an obligation to visit.
So the 46 regulations will have been under legislation before the 48 Act,
Indeed, yes.
of which there was an enormous amount.
Yes. 1933, presumably. So, my lady, my purpose in categorising them in that way, placement and removal on the one hand, administrative responsibilities, oversight, supervision, responsibilities of that sort, I fully accept they're in that category, but the category that they're not in is is the third category, which is parenting type of duties. There are in our submission only 2 regulations which fall within that category imposed upon the authority, and those, as I've said, concern the child receiving medical and dental treatment.
If the foster parent took the child to the doctor, and the doctor determined that some procedure was required for which parental consent would be required, would it be the practice for the doctor to seek the consent of the local authority rather than of the foster parents?
Yes, I think that follows from the expert evidence that you've already been taken to of Felicity Schofield. There were a series of important decisions which were always to be reserved to the local authority, and one would certainly concede that that would fall within those. It's the day-to-day parenting obligations that remain. We would submit entirely the obligation of the foster carer.
Well, the child remains in the care of the local authority while it is living with the foster parents.
Oh yes, in modern terminology, parental responsibility remains with the authority.
Yeah, and the local authority is the body under the duty to provide accommodation and maintenance for the child. And the foster parents, the arrangement it enters into with the foster parents is the means by which it performs that duty.
Yes. Yes. And returning to answer my Lord's question about the obligations, if that's the right way to put it, placed on the foster parents themselves, Regulation 20 requires them, well, I suppose one should say requires them, if they are to accept the placement of a child, to give an undertaking of which there is a pro forma at page 1652. You've been taken, in fact, to one that's been filled in relation to this claimant, but a different foster carer in the bundle. But that's the pro forma, and the important point for our submission, although it's not in dispute, is that point 1 is that the foster carer is agreeing to bring the child up as they would a child of their own.
Well, even this obligation is actually placed on the local authority, and it's body which is under the statutory duty to require the foster parents to sign the statutory undertaking.
If the placement is to be made, yes. I don't think it's necessary for me to take you either to the 1969 Act or the 1980 Act, as you have been shown the relevant provisions. I may have to come back to section 21 in due course, but in answer to the point raised earlier about what is the present day position, the bundle takes the matter some way further, because it includes the 1988 boarding out regulations, boarding out of children, brackets, foster placement regulations 1988. Those regulations, if I might summarise them, provide for very similar obligations as those imposed by the 1955 regulations, albeit they do so in more detail, and certainly, as one would expect, they do so in rather more contemporary language. But they don't, we would submit, and obviously I can take the court through them if it's going to be helpful. They don't fundamentally change, or really change at all, the substance of the relationship between the local authority and the foster carer in any way that may be relevant to the issues given that arise from the vicarious liability analysis. One sees the same sort of concerns: medical examination, duties of the authority in organising the placement, notices relating to supervision, termination of the placement, emergency placement, and so on. Those regulations didn't last very long, because once the 1989 Act was enacted, the 1991 foster placement children regulations were promulgated 1679, And again, a quick look through the various headings of the matters that those regulations deal with suggests that, again, albeit differently worded and with a good deal of more detail than occurred in the previous versions, they are dealing with very much the same matters. The other regulations that appear in the bundle are the 1991 placement of children with parents, etc. regulations. Now, they are there because they deal with the slightly separate question, and my lady referred to it earlier, that nowadays when a child is placed back with a parent pursuant to the provisions we've already looked at, where fostering, community home, voluntary home are alternatives along with placement back with parents or friends, that those are now the subject of their own regulations. This version is 1991. There are later versions, which I shall mention in a moment. But again, the comparison between the two choices for caring for the child is important in this case. And if one again looks through the headings of the matters that are dealt with in these regulations, one can see that, of course, whilst they're different, given the differing circumstances, they cover similar grounds: support and supervision, termination, and so on. The updated position, and these documents are not in the bundle, but if it's going to help, we are certainly happy to provide overnight copies for the court, but may I just identify what we understand the chronology to be. The regulations immediately following the 1991 foster parent regulations are the Fostering Services Regulations 2002. Now, these do get rather more involved because they're promulgated after the coming into force of the 2000 Community Care Act, and so they are concerned with fostering agencies, a creature of that legislation, so they are longer and more detailed, but they do deal with approval and placement of what one might call normal foster carers. And then they were replaced in 2011 by the Fostering Services (brackets) England regulations of that year. And as we understand it, those regulations are still in force.
That's what, 2003?
2011, my lord.
Oh, 2011, sorry.
And then returning to the subject of children placed with parents or other relatives, friends, etc., the regulations which replaced the 1991 regulations are the 2010 Care Planning, Placement and Case Review regulations. And again, as we understand it, those are still in force.
Well, they will be, but they sound to me to be dealing with something completely different.
They do contain...
The reason that I raised the matter when
Yes.
we were discussing it earlier is that what we have at tab 8, the placement of children with parents, etc. regulations, that covers placement with people with parental responsibility, whether they're parents, guardians or others who have parental responsibility. There must be another set of regulations that deal with placements with relatives and friends. Another set of 1991 regulations, all of which will have been maintained, replaced, or whatever.
Yes.
And because we were interested in placement with non-parental, non-foster parents, it
Yes.
would be good to look and see what the regulations say about that.
Well, we will endeavour to identify those overnight and provide copies tomorrow.
Identify will probably be enough, but it's...
Yes, very well.
Yeah.
Just before leaving the statutes, the relevant provision of the 1980 Act, which you've already been taken to, is Section 21, and I mention it now only to make the point that the statutory preference, as I have described it, for boarding out doesn't appear in that section, but you have the expert evidence of Miss Schofield, which you've been taken to already, which contains evidence about the fact that, at least from the 80s, there was perhaps a dip in the 60s, but in the 70s and 80s, fostering was again regarded by authorities as the preferred means of looking after children in terms of what was in the best interests of children, and has remained so since then, although perhaps finally I should mention, in the context of updating, that of course the Children Act itself has been amended, and the section now which deals with these matters is section 22C, and although it offers the same various statutory options, it has significant differences, including, for example, a statutory preference for placement with family, friends, and so on where possible. So there one sees the shift in
fashion.
Policy,
yes,
indeed.
yes. Could I ask you a nerdy question about these various statutory things? The 1980 Act was a consolidation act, and one notices that there were at least two significant changes from the 1948 Act, one of which was the replacement of the general duty, which was in section 12 of the 1948 Act, I believe, and with section 10 of the 1980 Act, and they are different.
The words are different.
Yes. And I wondered when that change had happened. And then the other change is the one to which you've just drawn attention, the removal of the implicit preference for boarding out over institutional care.
Yes.
And I just wondered if we could track down when the actual change took place.
Yes, we'll try to do that overnight, my lady.
Thank you very much.
Leaving then the statutory position and turning to the case of Cox and the indicia of vicarious liability, about which you've already been addressed by my learned friend. Certainly we accept as a starting premise that one needs to go very little beyond Cox in order to identify the principles that should be applied today. And we accept the premise that all of those indicia will not necessarily have equal weight, but do submit that the weight that should be attached to each of them will vary depending on the circumstances of the particular case. And I say that to introduce our submission on control, which of course we accept my Lord, Lord Reid, made some observations about, which may be seen as diminishing its significance in certain contexts. But our submission is that in a case such as this, where the issue is which side of the dividing line, akin to employment and akin to independent contractor, a case on its facts falls, then it is going to be important to look at issues of control, even if they are no longer, as was said by Lord Phillips in the Christian Brothers case, the critical touchstone that they once were.
I think what was said about this in Cox was really intended as a paraphrase of what had been said by Lord Phillips at greater length in the previous case.
In the Christian Brothers.
Yeah.
Lord, yes, and what was said there was that control was significant now, not so much because one needed to consider whether the employer had the right to control how work was done, but merely the power to control what was done. And we accept that, but our point, which we say is important in the context of this case, is that an independent contractor is generally, or the employer of an independent contractor, is generally going to have the right to tell the independent contractor what to do. And so there must be cases where there is that degree of control, vestigial control, as your lordship defined it, and yet no vicarious liability. So in a case like that, and our submission is that this is such a case, it is necessary to consider the question of control, albeit, of course, I'm not suggesting that it has any particular priority or is any more important than any of the other factors. One is not to treat these criteria like the words of a statute, as my lady said in Woodland, and one needs to look at them all, stand back and see where the balance lies, and that's what we propose to try to do.
That sounds like a convenient
Indeed.
moment.
Thank you.
Thank you very much, Mr. Ford. We will look forward to heering from you both again tomorrow. Court is now adjourned.